PR 43271, the State of Ohio versus Aaron Fields. Mr. Fields is before the court with his counsel, Mr. Gibbs. Ms. Nicholson on behalf of the State of Ohio. Ms. Nicholson.
Your Honor, it's my defendant will be entering a guilty plea to the indictment, which is 1 count of aggravated possession of drugs, a felony of the 5th degree, and there will be a joint recommended sentence of 6 months in prison consecutive to his current prison sentence.
Mr. Fields, you're telling me you're going to change your plea to guilty to the 1 count of the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I'm 3, sir.
How far did you go in school?
GED, and I took 2 college courses since I've been incarcerated, sir.
Okay. You're able to read and write? Okay.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you other than this recommendation to me that I sentence you to 6 months to be served consecutive to your current sentence? Is that the extent of any representations made to you?
That was the deal, but no one promised it to me.
Right, I understand. Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Gibbs?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what we're doing today?
No, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of aggravated possession of drugs as a felony of the 5th degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control on this case. I think your current case is mandatory,
Yes, sir.
but I'm required to explain it to you.
Okay.
All right.
Okay.
So on this case, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to, okay?
Okay.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished in any way unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury, and if you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that? At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Gibbs, the right to confront and cross-examine each of the witnesses. Do you understand that?
Yes, sir.
You have a right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you choose not to testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed, and you could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you feel like you understand each of these rights we've gone over?
Yes, sir.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We're not going to have a trial.
Right.
This is how you want to proceed?
Yes, sir.
Okay.
If this case would have proceeded to trial, the state would have proven that on or about March 6, 2025 at Warren Correctional Institution located in Turtle Creek Township, Warren County, Ohio, the defendant, who was an inmate at Warren Correctional Institution at the time, had his cell searched looking for contraband. A search of his person was also conducted in which he was found to be concealing a white object on his body. That substance came back as 5-fluoro-AVB, which is a synthetic cannabinoid.
Mr. Gibbs, anything on those facts?
Nothing further, Your Honor.
Mr. Fields, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes, sir.
What is your plea?
Guilty, sir.
All right, the court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Nicholson, anything before I pronounce sentence?
No, Your Honor, we just asked the joint recommended sentence of 6 months consecutive to his current sentence, which I believe has an earliest release date of May of 2035.
Reagan Tokes?
No, sir.
Okay. Mr. Gibbs, anything?
Your Honor, I would just like to note, well, again, we have agreed to this joint recommendation for the sentence, that Mr. Fields is taking many steps. He has attested to me over 50 different certificates. While he has been incarcerated, he's certainly looking to move past this and make the right steps forward for a productive future.
Okay. Mr. Fields, is there anything you'd like to say, sir?
I haven't had any trouble since this incident. It's been a year. I got rolled out to a higher level, and I've been up there about 13 months. I'm probably got about like 6 more months to do up there, and I haven't had any tickets or anything like that, sir. You know what I mean?
Where are you?
Okay,
Where are you housed now?
OSP,
Okay.
Ohio State Penitentiary, sir.
Okay.
And yeah, like I said, I've been up there 13 months, ticket free, staying out of trouble, working my levels, working my way back down, and I'm currently taking recovery classes up there, and I'm signing up for college again.
Okay. All right. All right, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So, Mr. Fields, I'm going to order you to serve 6 months in prison, that to be served consecutive to your current sentence. The court will make a finding that the consecutive sentence is necessary to punish you. It is not disproportionate to the conduct of the defendant, and this offense occurred while the defendant was already incarcerated in the Department of Corrections. You have 0 days jail time credit on this 6 months. The court does find that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control, which I went over with you a few minutes ago.
Yes,
Do you want me to go over that with you again?
Yeah, just real quick.
That's fine.
I know you said like.
Well,
so
I
for
think,
this
what are
case,
you
I've
in
been
for now?
Vehicular homicide.
Okay, are you
car
on
accident.
mandatory PRC?
I think so. Yeah. Yes.
Okay,
Sir.
so when you get out, the adult parole authority is going to supervise you on that charge. This one is not a mandatory PRC, it's discretionary, but you're gonna be under supervision with them anyway.
Right.
This one is discretionary, which means that they could supervise you on this one for up to 2 years. I think yours is 1 to 3 on your current charge.
Yes, sir.
And I don't know, they may pick 1, 2, or 3, I don't know what the answer is. This one's up to 2.
Okay.
If you violate the supervision on this case, the adult parole authority can send you back to prison for up to 3 months.
Okay.
If your violation is that you've committed another felony,
Yes, sir.
they can send you back to prison or the sentencing judge in that case can add time onto your whatever. If he sends you back to prison, he can add either 1 year onto that time for PRC time,
Yes, sir.
or whatever time left you have on PRC. So if
Okay.
you still have 2 years left and you go out and commit another felony,
Yeah.
and he sends you back, another judge sends you back to prison, he can add up to 2 years onto your sentence.
Okay.
It would be consecutive.
Okay.
Most judges, I think in my 10 years on the bench, I think I've only added PRC maybe twice to a defendant. Usually they try to work that out, but
Okay.
it's a possibility.
Okay.
All right.
It's just it's just discretionary. If they, on my original case, if they pick it up. Is that
If
what
you're,
you're saying?
I'm gonna guess, and again, I don't control the adult parole authority, I'm gonna guess you're on mandatory PRC, that they're gonna just not enforce, they're not gonna do PRC on this one too. It'll just be, you'll be on mandatory PRC. But the idea is still the same, and the penalties that you would incur
Right, are
on
still
that
the same,
case are more
yeah.
severe.
Yeah, or more severe. So basically, just
Yeah.
be,
So I'm guess,
be mindful of it.
yes, sir,
Yes, sir.
that's exactly the point.
Okay.
Okay. Now, you do have a right to appeal this court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal it, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me, sir?
No, sir.
All right, good luck, best of luck to you.
Thank you. Thank you, appreciate it.